public, and welcome to the committee members. Dr. Posse, great to see you. We also have Javi Arenas with us, and one of our lead counsels that we have through BSK, we have Mara Harvey with us as well. What I'm going to do is I'm going to start by just asking for some nominations from the floor to see if there's someone who would like to be our committee chair. Ms. Malconi?
I would like to nominate Deborah Brooks. Seconded.
Seconded. Are there any other nominations?
Well, I have some, but they would not accept it.
Not seeing other nominations.
And I now voted,
I will
so
call the question. All in favor? I see 3-0. Very good. Ms. Brooks, congratulations.
thank you.
She keeps winning.
It's I appreciate the vote of confidence.
Oh, we worked together for many years, and it's been a very productive committee, so I look forward to continuing that.
Thank you.
So the second item on the agenda is the approval of the calendar dates. We've worked together as a administration and trustees to establish the list of dates that you have there in your packet. If there's not any questions, can we approve those calendar dates for the year?
Yes? Yeah.
Very good. You also have in your packet the minutes from our June meeting. They've been approved by the board already, but they're here as a reference for you if you want to ever need to refer back to them. They're right there for you. By way of a personnel update, as you know, personnel flows all the time. We have people coming and going throughout the year. We were, very well staffed for the opening of school. I would share with you that the two areas that we're focused on right now of primary importance are getting teacher aides. We have about 5 vacancies right now for teacher aides. Some people refer to them as educational assistants or paraprofessionals. They support our kids on the playground or one-on-one in the classroom. So we're in the process of still trying to fill those positions. And we also have a vacancy in our supervisor of facilities position. You're aware that our most recent supervisor recently resigned to go become a director in another district. That's a civil service position, so we have to go through civil service and use the list of potential employees to hire for that. So we're in the process of canvassing that list, and we'll come back to you with a recommendation once there's folks that want to move forward. You also have in your packet the tenure review process timeline. This is something that we always share with the board at the opening of the school year. And it just lays out sort of the markers that we go through as an HR office throughout the year. The points that we want to make sure that you're aware of and how we handle the review process. And then we bring recommendations to you. As you can see, we bring them to the committee in the middle of February, and then we bring them to the full board after that around the first week of March. And then that leads ultimately to the tenure reception that I know we all enjoy going to in May.
And some of those tenure, the individuals who are up for tenure were on the recent Board of Ed agenda that we just adopted.
That's
approved.
Yes, very true. So sometimes we have people that we consider like a little bit off cycle. Most people receive their tenure in May for the following September. But we hire people during the year, and sometimes their tenure date is somewhere in the fall or in the winter. So we need to grant them tenure earlier. We still invite them to the reception, of course. So.
And we recognize them in May at the reception.
We do,
Okay.
yeah. We call them up and thank them and acknowledge them, yeah. All right, so the next item is 1.6 on the agenda. We're very glad that Mara is here with us. The first item that we're going to look to for support from Mara is policy 0115, student harassment and bullying prevention. Mara, you've spent a lot of time looking at this policy and along with the regulation as well. I know the committee has also done a lot of work with Mara behind the scenes in preparation for today. And that'll correlate also to the next few policies that we look at. That's why we asked Mara to join us today. All right.
Okay, just for the edification of the public, this is our current policy 5025. Just the NISBA numbering has changed. So we're now referring it to policy 0115, but if you're looking on the website, it's still 5025.
And just, I know that NISBA did change the numbers. You do not have to change the numbers, or you could keep it as 5025 if you wish, and just delete and change.
Yeah, the board made a decision several cycles ago to try to stay with the NISBA
Yeah,
numbering,
perfect.
and so we try to do that, and same with the titles.
Yeah.
When the titles change. Okay, so, Ms. Mawani, you're new to the committee, but, you've been here so often that you know that I like to ask the committee members if they have any comments before I charge in and speak, so I'm opening it up to my committee members for comment. What do you say?
I have nothing on this one. We've been looking at this for a very long time.
Yes. So I guess I will preface this by saying that, being new to this committee, I've spent a lot of time over the summer trying to wrap my brain around all 354 of our policies and exhibits and regulations. And it's been helpful to me to ask a few questions every time I'm looking at a particular policy. And the first is it legally compliant? And we have from Mara that it is, so checks the box on that part of the decision tree. Does it reflect current practice? And I think that's a question that I would ask our administrators in terms of this policy and all policies. Is it working to the extent that we know, to the extent that it's not a new policy, is it working effectively and as intended? So I'd also defer to our administrators on that as well. And does it support positive or improved student outcomes? So I feel like that's kind of the lens that I've taken to reviewing all of these policies, and maybe that will come out in some of my questions. So I hope they're not annoying questions, and that it's clear that they're focused on what I think is particularly important about policy.
So don't think any question is annoying. One of the things I could say is I had went into Howard Miller's office and said how impressed I was with how the district does review policies. I have many districts that I do the same thing. I look and make changes. And then when I see, and I don't think anyone ever looks and they just say, okay, great, that's good. And including where some of them is like, well, is this what you do? And there'll be comments like that. So kudos to you. There's never an annoying question. If it's something I don't know, I will look it up for you. And I do this for a lot of clients, so a lot of these policies I've kind of vetted through, the NISBA policies as well.
I had a few questions on student harassment whenever you're ready for that, after Jessica.
Yeah. I have a few questions, but I'd like to hear from Dr. Fossey on it.
I didn't mean to.
Before we get into it, no,
No,
I
I-
prefer it.
I just wanted to flag. So, I'm looking at the regulation, 0115R.
And just, we did a lot of redlining on the regulation because there was a lot of language in the regulation that was duplicating what was already in the policy and vice versa. So where you see things taken out of regulation, chances are it's because it's in the policy. So I don't know if that changes anything you wanted to say, but.
No, my question was more, it's a question for Mara, and I apologize for not sending it in advance, and if you need time to get back to us, that's fine as well. But my question was really about the, so particularly when it comes to the district level procedure and then the board level procedure. So I'm looking at page 5 and 6. So any party who's not satisfied with the outcome of the initial investigation, so the building level investigation, may request a district level investigation by submitting a written complaint to the superintendent within 30 days. That then prompts the district level investigation. So presumably then the superintendent or designee conducts a review of the building level process, makes a determination, and then if the party is dissatisfied with that determination, it goes to the board. The board then conducts a hearing. Time and place when a hearing will be held. So my question for you was, should we specify that hearing is a paper process rather than, or is it intended to be a hearing with testimony and witnesses and things of that nature? because that's unusual given other appeal processes that we have within the district. So I wanted to flag that just as a question for you. The other thing that I wanted to flag was that it seems like the mechanism to trigger a review is simply that you're dissatisfied with the previous determination. Should there be criteria, meaning new information, or is it simply, I'm dissatisfied with the determination at the building level, then dissatisfied with the determination at the high school level, at the district level, so therefore it triggers a board review, or should there be some criteria?
So the reason there's not a criteria, because really the criteria is I'm not happy.
Right.
The focus and the reason that I do think you want to have all these levels is the goal is to try to get it to stop and not go to the Commissioner of Education. So there is nothing saying you have to say, okay, to the building, to the superintendent, to the board, but if you don't have that, it could be the building, to the board, to the Commissioner of Education. The Commissioner of Education has had some interesting decisions over the past year, so I think it's best for the district to have as many, areas for
Sure.
to look at. Because often what happens, especially at the building level, is there's something going on. And a lot of times what happens is something happened. It may not be bullying. So bullying seems to be, and DASA seems to be the word du jour right now. And anything that happens with a child, it becomes that they're being bullied. So sometimes the parents are not happy with the building people because those are the people who are
Sure.
letting their child be bullied. So that's why you do want kind of the steps. With regard to the hearing, that is unusual. So we could change it legally to be a paper, that you could submit documentation in paper. I would recommend that.
You would not recommend
I
it?
would recommend that.
You would recommend
Yes,
it?
that it's by paper and not a hearing.
And how would you put that in words?
So I would say that you would submit, that the board would notify when a request for the review has been made, the superintendent will submit all written materials and other concerning. And then we could say that the family will be provided the opportunity to submit any additional written statements, documents, and the board will consider such appeal on paper.
So that would make it more in line with
A superintendent's hearing, discipline.
appeal.
And if you like, after this meeting, I could go in and
Yep.
change that, yep.
I'm just making a note there so I know to flag you.
Yep.
Is that acceptable to the committee? Because these are your regulations, right?
Yes.
Normally, we don't have a hand in that. If there's something glaring that we say, oh, well, there's something that involves the board and maybe we should speak out of that. So-
Yeah, the hearing stood out for me. That's why I wanted to flag that for consideration, because I know that if a student is dissatisfied with a discipline decision, it's typically a paper process. So that's why I wanted to flag that, as whether or not this should also be a paper process for the board.
So is it really a hearing or is it a review?
It's really a review, and that's really what the purpose is the purpose is to give another set of eyes, because look, maybe you see it, everyone comes to a process with their own background, baggage, information. So you may have a situation, I just dealt with this, it was a transportation appeal. I'm like, how could have you ever accepted that? And then I came to find out that, two of the board members, they get it because they were in a similar situation. So it's like you see things in different ways, and that's kind of one of the things I also think it's a good idea to keep different things. Especially when you're dealing with something that's it's not black and white bullying. Like, it is, there is
Can be,
room
but
for,
not- yeah.
some things are very black and white, but a lot of it is.
Nobody's saying it isn't happening.
Right, and under most circumstances, when you're dealing with that and you're dealing with bullying, something happened. It's not just like, oh, nothing happened. It's just a matter of whether it rose to that level.
And we want to be sure that we have the proper procedures in place. Okay, so would it be proper to call it a review instead of a hearing? And does the law require the word hearing?
Does not require and it's not going to say hearing, it's
Okay.
going to, the appeal will be reviewed. And I'm gonna use very similar language that would be found in the district code of conduct, which has the language for the appeals for superintendent's hearings.
And now just speaking about that for a moment, my original question was about whether or not there needed to be a reason to appeal. So meaning, and I don't, in some policies I've seen, it's new information, some bias in the investigation, or, a failure to follow the process, right? Like those would be the three reasons that would trigger an appeal. Does this need a trigger mechanism, or do you recommend not a trigger mechanism so that simply the standard is dissatisfaction?
If you have a trigger mechanism, what could happen is so the rule is that you have to follow the steps. You can't just skip over steps because you don't want to follow
Right.
them. So if we have, well, you could only appeal because of this, or this, and it doesn't apply, they wouldn't be entitled to do that, so then they'd be entitled to skip that
Right.
and go to the commissioner.
Okay.
Because the commissioner says any final determination could be appealed. So if we put in a kind of list of things it has to be, the argument could be made that they could have the right then to skip all of those steps and go right to the commissioner, which I don't think is what the
Okay.
district would, I don't think the district would want that.
And that also creates an incomplete record when it gets up, if it gets up to the commissioner.
Right, because then also, sometimes at the district level, it's not as put together, tied in a bow. And then as it goes up, it usually gets more put
Yes.
together, tied with a bow.
Mhm.
So that if you do get to the commissioner, you have that appeal that is put together, tied with a bow, and say, here, attach the documents that were considered, and they get to see everything, and it makes for a much cleaner answer.
Process.
Anything else, Dr. Costa?
No, thank you.
Thank you for the insight.
Okay, so,
Back to you.
yeah, thank you. I mean, that was helpful, and it speaks to my fundamental question of, does this work? And do the practices we are implementing actually achieve the goal of the policy? So thank you for that. Starting in the policy, on the first page, we provide right up front a list of definitions, which is helpful. But I'm wondering if within that set of definitions, the list of protected characteristics should mirror the list we provide in section 5 of the Code of Character, Culture, and Conduct, which also includes socioeconomic status, preferred pronouns within the gender category, and appearance, as in the code it's considered weight/appearance. I just feel like our policies should align on what we are protecting and how we are protecting students. So is that something that we as a committee should consider?
I think if the law permits it, we should have it.
Yeah, so,
Right? So there are some things the law requires.
so the definitions, these are the definitions, they're plucked right out of the law.
Yeah.
And the funny thing is with policies, I often don't like to do that, because then when the law changes
Yes.
and then, a word here or there, then the policy is outdated. Here, I think it is important because of the fact of what the policy is about, and people need to understand kind of what the definitions are. And they're not gonna know, or even if they do know, they're not gonna wanna go to the law to look at it. So, we can add in other definitions if.
Okay.
So we'll migrate the list from.
Yeah, I feel like wherever we are listing protected characteristics, especially in sort of a glossary of definitions, we should be consistent with those.
Easy to cut and paste.
Yeah. Moving on.
You wanted to know if we should move the definitions.
Oh, yeah, I mean, that's as a reader of the policy, taking a step back and assuming I am a community member looking to our policy to find out what my options are with respect to bullying and intervention. This kind of disrupted the flow. I couldn't really tell where the policy was going when it was disrupted by this very big list of definitions. So I thought it could potentially serve as a glossary to the, either a glossary in a exhibit, or at the end just moving it in the policy so that we can actually get into the meat of the policy and people can understand what we're trying to accomplish.
Yeah, from a legal standpoint, there's no problem, we could put it wherever we want, and maybe we put it at the end of the policy.
Sure.
So that it's still in the same policy, but isn't front and center.
I mean, I think it's user-friendly in a certain sense, even though it's disruptive, because it helps the reader prepare for what they're about to read.
Okay.
So perhaps in this upper area somewhere, or maybe at the end of that second paragraph, we maybe put some kind of an indication that, see glossary for terms
Right,
used in this policy at the end or something, just
yes, that would be very
if
helpful.
they struggle through the entire thing and they're like,
And they're like,
oh,
what's
I
national
didn't know
origin,
what it
right.
was.
Yeah.
Or what's protected.
Right,
Right.
So we could actually keep definitions and just put like one sentence of something to the effect of, definitions defined at the bottom, at the end of the policy, or we could even say is exhibit one, and maybe then now, if we're gonna reference it, exhibit one of the policy, and it would be just like kind of the last page of the policy.
Just so that people don't struggle through the reading of it, and then they're like, oh, now I understand what that was supposed to
So
mean.
it's applicable definitions.
I think we should keep it within the policy.
Yeah.
Yeah, because we have we do have an exhibit that's the harassment complaint form, and I think that's the really important exhibit.
Mhm.
And I just don't wanna have people have to search so much for so many things.
Okay, so what we could do is we could say applicable definitions found at the end of the policy, so keep definitions and then move the policies and put them to the
I
end.
think that works. Great. If we're looking at page 3, again, this is a question of consistency across our policies, and just to make sure we are articulating all of the traits we're protecting. On page 3, second paragraph, said staff member must be thoroughly trained in human relations in the areas of race, color, weight, national origin. This should mirror the list we share.
Am I reading the wrong?
No, it's the
Okay,
first
so
full
it's the-
paragraph on page 3.
Right, I said second
It's in the
paragraph, first
middle.
full paragraph.
It's in the middle, somewhere in
yeah.
there.
Got it.
I think the question is, it's about being trained. And so is there a legal requirement? Is that what you're asking?
Is there a legal requirement to include this particular language? And if not, should we list all of these characteristics again? Is it redundant? Or could we say thoroughly trained in human relations and the protected characteristics of, how do you wanna frame it,
Under this policy.
under this
We could
policy?
say,
Yeah.
So, we do not have to say, what is it, or the idea is that they are trained to deal with DASA and trained in order to implement this policy. It is not just the areas, so we could make sure that they, that are thoroughly changed in all areas involving dignity, DASA.
Yeah,
and this policy.
yes,
This policy may contain protected
yes, maybe more
Areas that are
expansive.
Right,
Yes. In
to
this policy, yeah.
DASA and this policy,
Under this policy, yeah. That's great.
I forgot that at this point, I did have I often focus on the consistency of our language. So intervention and remediation seems disconnected to page 5, which is consequences of remediation. So I was wondering if there was a reason that it's separated out that way, and if we wanted them together.
So the the first portion is really more about kind of getting ahead, trying to get ahead of issues.
Doesn't that fall under prevention?
We're getting ahead of it and intervening, so we could probably incorporate it into prevention.
It could, maybe then it could be prevention and intervention, because they're two different things. Prevention is preventing it from happening, and intervention
And then
is
you start seeing
you
it.
start seeing it, and you're insinuating yourself into the situation.
And then is that the appropriate place where we add the consequences / remediate, well, we're using remediation again, so it just seems disconnected with how it's organized.
So I actually think maybe the way that we would help it is moving the consequences and remediation to right after intervention and remediation.
And I don't think we should use remediation twice, right?
It would be consequences,
Right.
the second one.
And then if there's any remediation language in the consequences remediation paragraph that wasn't addressed in the intervention remediation, let's be sure we have that.
And I guess, my question around prevention, intervention and remediation in those sections is for our administrators, does this reflect our current practice? Is our practice, because this reflects what DASA requires. Are our practices more expansive? Is there anything that we should be including here to reflect practice and help the board measure our effectiveness on preventing bullying, harassment, and discrimination?
I would say it does represent our practice.
Okay.
Yeah, and there's training that takes place. We have multiple levels of training, through an online platform called GCN as well, that have different required topics that we make sure our staff take throughout that year.
A question that comes up in this category as well, in all of the categories really. A program geared to prevention is designed to not only decrease incidents of bullying, but to help students, et cetera, et cetera. So we've stated clearly the aim of this policy is to decrease incidents of bullying and, protect students who
page 2.
find themselves victims of bullying and harassment and discrimination. Should we, as a board, because this is board policy, is there anything we want to include in here regarding the accountability on that, on measuring or at least report, some sort of reporting? When do we as a board see information about bullying incidents, harassment, discrimination, DASA complaints? Where should we include that, and should that be part of our board policy?
For some reason, I feel like we just did a policy that talked about building level incidents of something. Was
that's
that the
in the
safe
code.
school?
No, oh, yeah,
Oh, the school safety, the SSEC one?
Yeah, no, is that?
It was passed over the summer, I believe.
Yeah, so is it,
What a
is
memory
this
you
in,
Mhm.
is this in that one? Is that what this with the building level incidents?
So we have our SSEC filing that we do each summer.
Right, would that satisfy this request?
So if you look at page 6, I think it's each year as part of the annual review of the Code of Character, Culture, and Conduct. This policy will be reviewed to assess its effectiveness and compliance with state and federal law. If changes need to be made, revisions will be recommended to the board. I think that part of that review would be looking at the prior year's incidents to see, because if you see, okay, well, we have 100 instances, well, then
Right.
that was something that maybe
Yes,
the
and I
policy
think my
needs to-
question here for
Okay, no,
fellow
no,
trustees
yeah.
is, we could review this policy every year without ever seeing any reports, and we wouldn't necessarily be moving the needle on anything. So is that something we want to reflect here as a desire for that level of incident reporting?
Are you looking for like tally information, like in other words, how many instances of bullying were reported, how many were founded versus unfounded?
Yeah, and the sort of the escalation, how many rose to this level, how many were, what was addressed
Right.
at the varying tiers of intervention. I think that would be helpful to the board over time to understand if our policy is working.
I ask because that tally information is part of the state reporting that we do.
Yeah.
So, and we monitor that in our student information system. As part of, as part of that annual state reporting. And I do believe that in the character and code of
Plus
character.
CCC.
I've never gotten it
C
right.
cubed,
Yeah,
code cubed.
there is reporting that's required as part of that policy.
So do we need references to that here? I'm just kind of wondering, because we're gonna go through this again next year, right? It's required that we review this. What are we as a board looking for in that review process, and should that be governed by policy? The answer may be no, but I'm just putting it out there for us.
So the first thing I remember, this paragraph is not required by law. I remember there was a comment, maybe somebody asked along the way, that each year as part of the review, this policy will be reviewed to assess its effectiveness. So maybe,
So the code of conduct, you do have to, I'm
Yes.
sorry, the code of CCCC.
Yes,
You can
that
call
is
it
a
the code of
required.
conduct. We know what you mean.
Character, culture, and.
Character conduct. And look, I think that's great, like, so don't, I'm not,
I
having a
think,
child that just is going into middle school.
so the annual review of the code of character, culture, and conduct is mandated by law, but it's not mandated to review this policy. So, by state law anyway. So I'm wondering, instead of saying as part of the annual review of the code of character, culture, and conduct, can we say, each year, at the end of the school year? It's not that the policy, I don't know if the policy needs to be reviewed, like, this is where I get hung up sometimes, because sometimes the policy is a really good policy.
Yeah.
And it's being implemented with fidelity, but you have little human beings, right, in school
That do little,
that
crazy
don't
things.
care about the policy and what adults are trying to accomplish through curriculum or classroom or anything like that. So I'm trying to get to.
It's
what
more like
you
if we're
would-
getting this information, if as a board, if we're receiving this information on some sort of cadence, that could potentially trigger a review of this policy, right? Like if we're seeing trends over time and we say, you know what, our policy isn't working, we need to have a look at that policy. If this policy isn't required to undergo annual review, maybe that's part of it. Maybe it's reviewing data that's required under other policies, but I think sort of articulating what that cadence is and what our expectations are of each other, you know, of us as a board.
And I understand that. What I'm saying is it may not be the policy that is creating the issues.
Right.
So I don't know that I want to limit it to the policy needs to be reviewed.
Right.
As opposed to what's happening in the
I
I
building.
think that's what
It's
she's
That's what I'm
asking.
saying. Oh,
She's
yeah.
saying she wants
I think
the numbers to see if the policy is effective.
the policy and practices, I think it's
Policy and
the
practices,
two.
yes,
It's-
Right.
policy and practices together, that
Okay.
if we are observing trends, that, and maybe the trends support the policy, maybe it says like, this is working, we're seeing a decrease in
Or there's a building
incidences.
that we're seeing something happening in, or there's lots of ways that it can
Right.
actually manifest in real life.
Right, and it may force us to ask, like, is this policy flexible enough? Is inflexible, is it too specific, right? I think we may find ourselves with those questions, but only if we have the information.
So I think it should say policy and practices. Because it may be that both are fine and there's just an issue,
Yeah.
among
Yes.
the little people.
Yes.
The young people. So then, this policy and practices, and the data comes from the what report again?
SSEC.
Yes, we have the SSEC report. You also receive in January and in July suspension summaries of what has happened in each of the schools. And we also connect that to attendance data as it relates in each of those schools by grade. So that's something that the board asked for this past year that we've put into place, so you can see more data around student outcomes.
Okay, so the SSEC policy is actually referenced, it's cross-referenced. So then, can we say each year, this policy and practices will be reviewed along with SSEC data and suspension summaries? We can flesh it out, behind the scenes, but would that be a good.
Yeah,
Is that
I think so.
what
I
you-
think sort of just making that explicit in this policy, that these are the information sources the board can use on a regular basis to assess the effectiveness of this policy would be helpful.
More?
No, I'm gonna leave it to you.
Alright. So the first question I have on page 2, after the little fourth circle that starts with Herzog School property, in our, either our current policy or the NISBA version, I can't tell, where there was a definition, I'm looking at the, I don't know if everybody has it though. I'm looking at my version from May. Under harassment, there was, the harassment paragraph was converted into bullets. And the very last, second to last sentence says, acts of harassment and bullying shall include but not be limited to those acts based on a person's actual or perceived identity group. And that sentence got lost, and I don't know where it went. But is that something that's elsewhere in the draft that we have in front of us?
So I believe, and I'll verify that the harassment and bullying, that the language, we made it consistent with what is in the law. So I will go back and double check the language in the law and make sure it is consistent.
And that is the language in the definition of discrimination as well.
So if I could just say something quickly, these definitions that are currently in the policy were copy and paste from the code of conduct. So everything you see here is everything from the character, culture, and conduct. So we just copied and pasted because the decision was to align it with the belief and the practices of the code.
How good are we?
And as Ms. Malwani pointed out, it is currently part of the discrimination.
Yeah.
So that's okay, so it's covered. Okay, I'm satisfied with that. Thank you, Javi. Let's see. Just wanna make sure I haven't missed anything. On page 4, we have a yellow highlight. It just says cross-reference the exhibit, and I think does anybody have a problem cross-referencing the exhibit, and the exhibit is going to be the harassment complaint form?
In lieu of embedded hot links, which would be ideal. To be able to link over to the
So,
complaint form.
and I'm a better lawyer than I'm a tech person, so I'm gonna start with that. Is I believe that even if it's still, you could still do a link, like you could say it's, exhibit, blah, 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 whatever, and have it that it's an active link on the website to go to, even if it's 2 pages
Yeah.
down. So I think that is a good idea, so that you can get there right there.
Yeah.
Except our website is always changing, but we'll do our best.
Yeah.
We'll at least say see exhibit 1.
Well, but it's also, if the website's changing, I think it's even more important to include it than to,
Yes.
and include, say, exhibit, whatever, so that when the link doesn't work, because
Yeah.
everyone, it's always moving. It leads to
While
thing.
we're in that paragraph, can we talk about reported? Because the way we talk about reported makes it seem as though it is available to everyone in the district, and it is available to everyone in the district, but in practice, it doesn't. There have been a lot of discussions about how it works for elementary students and parents versus how it is intended to work for secondary level students. So is this, we need to include it in this policy. We need to make clear that we have a method for anonymous reporting. But if anybody digs into that, they're gonna say, oh wait, but I'm an elementary parent, and if I use it, it's gonna go to the high school, and then it's gonna go to the middle school, but parents aren't, it's really not the parents who are encouraged to use it, it's the students at the secondary level who are encouraged to use it. So how can we frame this in a way that is true to our practices and how it is implemented in our district?
So reported is not available on the elementary website?
It's not promoted at the elementary level.
So how would, at the elementary level, how would an anonymous because reported is for the anonymous report. So at the elementary level, how would a parent or student file an anonymous report?
So now usually with the anonymous report, it goes to certain people.
Yes,
Maybe the way to fix it is if the elementary principals aren't included on getting it like that, it has like what the student's name is, and then you add the people who get the anonymous reports, the elementary principals, and basically the training would be, you would look at the name, is it, you know, a child in your school? If it is, then it's yours, if it's not, it's not.
so my understanding, based on lots of discussions about this over the years, is that it's not promoted at the elementary level, but it is available on our website, so anybody can use it, and if an elementary parent was to use it, it would go to the designated, trained administrators who are dealing with it, and if it's, then they would have to look at, oh, this took place in a different building, and send that
Then
information to
forward
the,
to
yes.
the administrator there.
Yes, but it's more a matter of the fact that it's not readily available at the elementary level in the same way that it's promoted throughout our secondary schools. So our policy makes clear that it's here and it's available to everyone. Do our practices need to reflect that, or does our policy need to reflect the practice?
So when you're dealing with, I guess from a Lily, when you're dealing with reports of bullying and it's anonymous, it becomes very difficult.
Yes.
So my recommendation is that, you know, the recommendation to the community is that, we want to deal with this, but in order to really get to the bottom of things, it's very difficult when you can't talk to people or what happened, what did you see, there. So I understand the idea of some people, they won't say anything unless they're not a target. But in most cases, it's pretty obvious if it's, this child is bullied. In many cases, it is the parent and just saying anonymous, but we just don't know that. So, but yes, we should make sure that if we have an option, that it is available.
But we
I
also
think
don't
it's
wanna make it
really-
seem
we
like
don't
it's
wanna
not
make it
available,
not
because it
available.
is available.
So I think that,
I think it's a practice question that
It might be a
It's something I
practice.
could look into.
It's interesting, on the website, it's only listed under district, it's not on each school's page,
So
it's
it
on the
is
district
so it is compliance with, so
drop down.
it is compliance with what the policy says, is available.
Right. And I have seen signs in our buildings in high school and the middle school so that students know it's available. That is not the case in the elementary schools, and I understand why. So, yeah, maybe we need to just take out that
To the extent it
parenthetical
is
to the extent
available.
available, because
Yeah, I
it is
get that.
actually available to everyone.
Okay, so in the next paragraph, there is a paragraph in the NISBA version where it says, in some instances, bullying or harassment may constitute a violation of an individual's civil rights. The district is mindful of its responsibilities under the law, blah, 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 blah. That paragraph, I don't see that paragraph here in the policy. Is the violation of civil rights, is that what triggers filing a complaint with the New York State Division of Human Rights?
So they could file, so realistically, they could say that they've been discriminated against, and then therefore they're gonna file the complaint.
Okay, and so this paragraph from the NISBA version that talks about a violation of an individual's civil rights, where could that language live?
So we probably could put that right kind of where we're talking about, right above that,
Okay,
so that all the stuff dealing with, and so this is what it is and here's how to do it.
okay, I have the language, I can
Okay.
kind of paste it in there. On page 5, the last, under the consequences remediation section, which will be moved, the last sentence of the first paragraph. If the behavior rises to the level of criminal conduct, law enforcement will be engaged. That's very passive to me. So is there an affirmative requirement on the district to involve law enforcement?
There is not, obviously it depends on what happens, is about whether you'd be criticized or not. So if like kind of the more severe it is, and if it was, and we didn't involve other people, I think you could be criticized. If it's one of the more minor ones and you don't,
No, I meant in the instance of rising to the level of criminal conduct activity. In that instance, is there an affirmative requirement on the district to involve law enforcement? Like how does law enforcement, in other words, this sentence says, if the behavior rises to the level of criminal conduct, law enforcement will be engaged. Who's doing that?
Right,
Like
so
how is that happening?
so we may wanna change it to may, because so for instance, I'm gonna say an assault. You know, you have a normal fight, there's an assault. Most districts do not call the police every time there's just a normal fight. So there is no requirement that you have to call. Usually you're calling it, you know, as a brawl, you're calling them. You know, there should be some level of just
Serious
and disruption and, you know, what it is. Traditionally, districts are not in the area of, let's try to have kids have criminal issues. When it's not
Of
necessary,
course, especially here, yeah.
yes.
Because we try to, we're, you know, the restorative justice and Officer Tony trying to smooth out whatever there can be without the criminal implications. So,
So we could say may be engaged, so that it's a more,
but by whom? So I just want it, like, by the parents, by whom? This is
a policy for the district,
The
right? So
district.
the
Yes.
district would be obligated.
So that's what I'm asking, is there an obligation on the district, if this, so I'm a former public defender, so this kind of like was like, whoa, by
so
whom?
this doesn't,
Also prosecutor, but,
so the other, I could answer it this way too. We could delete this sentence and it doesn't mean that we can't call the police if we need to.
however, I think it's an important consequence of which parents should be made aware
Understand that this is possible.
that this is possible. So personally, I would like to leave it in, I just want it clarified.
So I think
By the
we say,
district, is that
yeah,
what
so I think we said, if the behavior,
Because it could be any administrator that reaches out.
So by the district,
And are there, I think to that
I
point,
think it would say may instead of will.
may.
if it could be removed, are there any circumstances under which law enforcement must be engaged, that where the district has an obligation, and should we articulate that in policy?
My suggestion in experiencing it is, if we think there's something that we must bring to law enforcement, we contact counsel and say, here's the situation, what do you recommend? So we always seek advice to make sure we're following the law.
So there's no affirmative, unlike child abuse, for example, where there's an
Right,
affirmative.
affirmative is
I don't think you'd wanna put in a list,
Yeah,
Yeah,
Right, yes.
because there may be things
Yes.
outside that list that we would still contact law enforcement.
so like with child abuse, when you're a mandatory reporter, certain things happen, and often, even their districts will call, and I would say, if you felt you had to make the call, you're gonna hang up with me,
Right.
and you're gonna call CPS and let them do, and then call me back, and then we can have the discussion.
Right.
So how about the district retains the discretion to engage law enforcement if the behavior rises to the level of criminal conduct activity? Is that okay?
Such a good lawyer.
Okay. Because I think that puts everybody on notice that this is not a game, that, okay, there has
So there could be
Potential-
seriousness in it,
potential,
yeah.
yes.
Just because it happened in school
School
doesn't mean that
it's, yeah.
Okay, on page 6, under training, where we have the district's professional development committee, this is distinct from PGCD, is that correct? So the professional development committee is out of the curriculum office?
Mhm,
As
it
opposed
is.
to, okay,
So it's
and that's
separate
what it's
from
called?
PCD, yep.
Okay. Still in that paragraph, it says training will be provided annually for all staff. Is this happening?
Yes.
Okay.
Traditionally, districts use GCN for that.
Mhm.
And if ever
We do as
you,
well.
and if ever you want to have additional training, our office could do DASA training, whenever needed.
Okay, those were the only questions I had on the policy
I have stuff on the regulation.
and the regulation. Do you wanna go
that this committee has tried to really focus on is consistency of language again. So, I'm just asking if, for example, page 5, paragraph starts, appropriate disciplinary action. We've kind of moved away from disciplinary action in writing the code of conduct. Do we want to use the term, I think we've often used
Consequences? So appropriate consequences?
And then I think I have it in others. I may have missed others, but I think I caught page 7. It says disciplinary measures in the middle of the
Yeah,
page. And I think that's.
and then under students, it would be consequences may range right after that.
Oh, I missed that one, see, I didn't. Oh, and, well, how do we, and employees too?
Why not?
Okay.
Unless a consequence for an employee is legally called a discipline, I don't know if that's has a
I actually
legal
prefer
significance.
consequence, because discipline, we could get into trouble dealing with, you know, because when you're disciplining and you have tenure rights, you have 30/20A and.
So consequences is better.
Right.
Okay.
Okay.
I said, and you know, obviously here it does say including termination. It's not,
Which is-
it's not as easy as,
Right.
you know, as it makes it seem by this piece of paper, but
Well, we
we
also,
all know that.
as a committee, have tried to really focus on tone, and consequences is just a.
The only other question I have on the regulations is the last paragraph before letter B, district level, where we're talking about any party who is not satisfied by submitting a written complaint to the superintendent within 30 days, and I always say of what? What is the triggering event?
It is of the receipt of where this is the superintendent, the district level, so receipt of the prior decision.
And then, are we okay with our harassment form? Is there anything that needs to change?
Can I just ask a question on page 5 while we're on regulation for just a moment? If a complaint contains evidence or allegations of serious or extreme bullying or civil rights violation, the complainant will be referred promptly to the superintendent. The complainant will also be advised of other avenues to pursue their complaint, including contact information for state and federal authorities. What does that look like in practice? Is there a letter that council provides us?
And we could give you a letter, but that's when you're dealing with the stuff about, we were just looking at the language, when you're going to, New York State Division of Human Rights,
Okay.
so.
Which
I
is
could-
actually in the policy.
Yes.
On page 4, the reference that is in the policy, but not to federal. Okay. And then is our harassment complaint form up to par? You don't have to answer that now, it's an exhibit, so.
So I will
The last
review.
It's the last one in the packet.
It's a part of the regulation, it's stapled all together.
And you don't have to look at it now under the gun merit.
So what I will do, because I've created some, so I'll go through and see if there's anything you want to add to give more information, because the more information that you have on the complaint form, the better it is. The one thing we always also want, I always like to remind is that they don't have to use our complaint form. So a lot of times I'll have people come, I'm not using your form, I'm just wanting to send an email. You know, you're gonna accept it. You could say, look, you know, this really gives us a lot of information we need, it will expedite, help, you know, you could try to get them, you know, or I'll write it down for you. But, you know, I do like to remind that we do not have to use, they do not have to use our form. But I will, look at this and I will let you know if there is any additional things I think we should add.
Thank you. There's the complaint form and the appeal form attached to that. So we're almost at 11 o'clock. Is it okay if we,
Worried we didn't have a full agenda as usual.
yeah, is it okay if, with the committee, if we, because Mara's here, if we skip to policy 5550, because that's a required policy that we do not currently have. And if we could start to make some headway on that, I would feel much better.
Just a quick question.
5550, student privacy.
Yes, the policy 0115 that we just reviewed, just for me as a point of learning, and where does this go now? Where,
It'll be it'll be edited by Mara.
Yep.
And brought back to the committee for review.
Because sometimes we'll do, after having a major conversation, we'll make edits and we'll put it on for a first read.
Yeah.
But because this is so extensive, I think it's a good idea
to come back and review the
That's what I should have
version
said.
and.
Ms. Brooks, you'd like to go to the new policy of 5550?
If the committee agrees. Okay. Does anybody have anything to say before I say?
I found, page 2, that list. I'm so baffled by this entire thing about a survey.
It's straight out of the law.
It's straight out of the law.
I knew that was gonna be the answer. Anytime I'm really offended by something, I'm told it's the law.
Yeah,
Why are we allowed at all, as a school, to send a survey that has any of this content? How is that not illegal?
so the one thing that I often get confused with this policy, and I'm not saying confused by you.
Oh, I'm confused.
Parents will read this policy and they'll say, wait, the teacher just asked me something about, income. And so for instance, the free and reduced lunch, I know that's not really as much of an, an issue here, and includes ask for income. And like, the policy, it says you can't ask us unless you can't give me permission. This only applies with the survey, student, US department. So this doesn't necessarily, so most schools, you're not really giving out surveys with this, but they still have this weird law. It's FERPA and PPPRA.
Okay, as long as everybody agrees it's weird, I'm good with weird.
But Mara, to your point earlier, about sort of like elucidating the language of the law in a policy versus referencing the law, which is, can evolve over time. Are we required to list these 8 features of surveys in our policy, or can we simply reference the law as to what's allowable?
Let me look, because I'm not positive that I think it's maybe, so the one thing of referencing the law, it's not really doing much for the policy, because no one really knows what it, what it is.
Right.
I have to look to see if we're able to.
And I think it's also important for especially classroom teachers to know what might trigger this, because that's where the surveys will be given to a student, right? It's not gonna be the principal or superintendent's gonna interact with in the classroom. It's interesting because in my daughter's, I can't remember, maybe algebra class or geometry, they were using Edmodo. And they were there was a survey on Edmodo asking for political beliefs. And I saw it and I thought, what is this? I don't understand, why is this happening? And they were just trying to gauge percentages. There was some math thing that was involved in that, but it came up in this Edmodo platform. And so I shot the teacher an email and said, do you know that this is happening? Now, it wasn't a Department of Education survey, but sometimes these things creep in anyway. But it has to be specifically from the Federal Department of Education, Mara?
Yes.
So I understand some of them because for some reason, this even covers districts that do physical examinations. So I get that, like, some of this sounds just incredibly personal in terms of people's health. But I understand, when I went back and saw it, I'm like, okay, this is about physical exams as well. This is such a broad policy that covers so many things, so I guess I understand some of the stuff on the list, but some of it I just.
So this is really, it's actually supposed to be very narrow, like it's the policy is really very narrow, because it's only really dealing with, for the most part, the surveys that are US Department of Education funded surveys. Obviously, we're in a world where asking political affiliations and all those things, I would hope that most of our teachers know that that's something we don't want to go anywhere near. I think obviously bigger problems, and it's not PPRA problems, with regard to that. But a lot of times people, they're looking for, they'll look in political and find the fact, oh, look, I found the policy, there shouldn't have been, anything asked even or talked about. It's really more the speaking about than the asking. So where it does come into schools, and there's definitely appropriate times, is talking about different political areas. I mean, social studies classes, you're gonna be having those discussions. That's where sometimes this policy kind of gets thrown in your face.
So when we get down to option A and option B, there's no wholesale ability to opt. I don't want to misspeak. I feel like there's no. It's like brain teaser. I looked at it and I feel as though there's always an option to opt in, but sometimes an option to opt out. In other words, option B requires opting in for all surveys regardless of the funding source or voluntary status. So there's no ability to opt out of everything. You can either opt in, you can either have an opt-in option or a hybrid opt-in, opt-out.
So with option.
No wholesale opt-out.
So with option B, if we say that if we do not have an opt-in, they are opted out, that they cannot do it. So with option B, if you look in the event plans to survey to gather information, including the list above, regardless of the funding type or whether voluntary or mandatory, the district will obtain written consent of the parent in advance of the survey.
So the
So if
district
we
must
don't
then.
have consent, we cannot do it for that student. So
But that's not an opting out.
So I guess it's,
Then it's just by default, they can't be given the survey. In other words, an opting out requires an affirmative action on the part of the parent to say, no, I'm out.
Right.
As opposed to the default being they didn't do it, so therefore they're out. I mean, one requires it, they both require affirmative actions on the part of the parent. And so I just want to be sure that we are really, really clear in this policy what a parent is required to do. Because I find this well-intentioned language to be very confusing.
okay, so the purpose of the opt-in is, so for many parents, they're ignoring, you send parent squares, you send letters, you send all those things. So we'll talk about it after, like directory information is one, it's an opt-in, it's not an opt-out. So it's assumed, it's an opt-out, sorry, not an opt-in. With regard to directory information, unless they opt out, you're allowed to do it. This is one, so where we could say, we will not give your child a survey unless you opt in. So that those parents who you gave plenty of opportunities to do something, that just either ignored it, they have bigger things going on in their life, or they just ignored it because they don't want to look at it, their child would not be given a survey unless they came in and said to do it.
Yeah, I want to be really clear what is required of the parent, because
So maybe we could even add, if we decide with option B, we could add a sentence that says, if the district does not receive anything from the family, the child will not be served, will not partake in the survey, to make it clear that if you don't do something, you're not gonna get it without their consent.
and so
I was just gonna ask philosophically though, are we saying that we want to collect the data? Or are we saying that we want to lean towards less kids filling it out? Because the choice, by the mechanism you're going to select, it will drive participation. So I think what you were starting with was the opt-out version, and that's not a choice in the language that's provided to us. Because if it was a purely opt-out, you'd have very high participation. If you're saying that participation is not important to us, then you would go for the opt-in choice, because the reality is that
Less people
people
are navigating.
far few people are gonna opt in.
And I think the question is, why are we administering surveys that are not important to us?
Well,
So-
Are some of them driven by the federal government? I mean, are some of them required? Is there any, right, what is the reason that these surveys would come in, especially the US DOE? Because it,
Well, they don't even exist, right? I mean, they have some level of non-existing right
Right.
now.
so, but it says, and the survey is part of a program funded by the US DOE. So that's this, it's not just that it's any old survey, it has to be funded by the US DOE.
Right.
Then there's the opt-in. Otherwise, any other survey, it seems to be, they opt out. And that could be any survey.
Could be our climate
Maybe-
survey,
Maybe,
right?
maybe there's a survey in one of the health classes that asks about sex behavior or attitudes. I don't know. But maybe that's just part of an anonymous survey that the kids fill out. I don't know. Again, I'm saying,
Yeah.
I'm just thinking of an example of where this might happen. Or maybe in a gov class, there's an anonymous survey where the teacher wants to know, do you even know what your parents' political affiliations are, and fill out a survey. I'm just making this up, I don't know the answer. But, and that could be, I don't know what kind of educational value that might have. I leave that to the classroom teacher, but I'm just trying to make it as clear as possible for a parent to understand what this means.
Understood.
While not impacting,
Well, I think the first decision, to Dr. Shields' comment, is that we need to decide philosophically, because that will determine which of these options we're choosing, and then we can figure out what language creates the most clarity. To my mind, an opt-in model seems unwieldy and unnecessarily limiting, particularly, to Deb's point, if the district or a classroom teacher is administering a survey that clearly, we have to assume there is value if the district is doing it, and that the information is important to help the district or the classroom teacher do their job better in some way. So I am not supportive of an opt-in only model for all surveys. I think it really limits our ability to do the work of education.
so then option A is what you would choose.
Yeah.
Because it seems as though there's no.
If it's only one or the other, then it's
Yeah,
option
it seems
A.
as though there's no opt-out version for the US Department of Education survey. It seems like it's only opt-in, 'cause I don't,
So I think the first one, I mean, I could make it clear if we want to say that like you're in it unless you opt out. So kind of like the directory information, I could make language to make sure it's consistent with that.
but for some reason, and I don't, is it in the shaded area? It says, if a US DOE funded survey would reveal certain information, then prior written consent must be obtained before the minor students are required to participate. So that is only an opt-in, right? You have to
So
get
that's
prior
the,
written.
so I think what that is what this is saying is for the US Department of Education
Correct.
ones,
Correct,
that you have to opt in.
right.
But
There
then
is
the
no,
other
yes.
surveys, which I think is what I'm kind of
Yeah.
hearing,
Is opt-out.
Is opt-out.
the
That's
US
option A.
Department of Education ones, you need to opt in order to do it.
But we
But for any other surveys,
language.
We do, option A. And
So
Oh,
if you,
okay.
so the
Got it.
first sentence
Got it.
is saying that funded by the US Department of Education,
Right.
the student may not participate unless we have written consent.
Yes.
Right, so that's not an opt-out by default is what I'm saying.
Right,
There's
it's-
only one option for the US DOE, and that is to opt in.
You opt in.
So.
but then-
Yes, and this is a very small change, but it might help, because the language to me actually is clear, but I think starting with the sentence, if such a survey is funded through other sources, can we make that a separate paragraph, just to separate the thoughts?
Sure.
And then I think that becomes a little easier
Because I think
to-
that's what I'm hearing is,
Yeah.
Yes.
I think, and this is you know, kind of cross board, like if it's a US Department of Education and it's one of their, it's funded by them, which I don't even know that there currently are any,
It's rare.
I don't even know,
It's gonna be rare.
it's gonna
Yes.
be rare, and if it is, it's like, you know what, if they wanna do it, okay, we'll give it, and parents have to consent to doing it.
But if the
But
district
if the
is
district is doing a survey, we're doing it probably for good reason. And, you know, so you want people to do it, so the people who ignore it, well, you know what, you lost your chance to, you know, we gave it, it's, you know, we could maybe put it in the calendar, you could put, you know, put it on parents, but whatever, of the notices,
Yes.
with regard to, you know, that.
May I make my, okay, so now on page,
So question, but
Yes.
if we're applying for a grant, is that a US Department of Education funded survey? And let's say, so for example, there are some
it's a
grants that
student, it's
require.
student surveys.
Right, there are some grants that have required student surveys in order to, so for example, grants that deal with substance abuse and prevention, you know, that sometimes require surveys of kids that, in terms of use, you know, prevalence, what do they know about their friends, things like that. So,
So this wouldn't be included in any of those, like, so again, you would have to kind of,
yeah.
but it would also depend, is it a US?
I think it depends on the
Department of
funding source
Education.
based on the language.
Yes.
no?
Tangentially, right, tangentially, because in order to qualify for the grant, you would need to survey your students, and so then this would be an opt-in
It
to
would be an
survey the
opt-in.
students for that purpose. You couldn't just say, you know what, this information is valuable to us. In other words, the information could be valuable to those kinds of surveys are valuable to the district because it tells us the prevalence of substance use in the community. But it could be problematic for us to survey to get that data
So the district would be able to survey to get that data.
and not provide it to
And-
the US Department of Education.
Well, so if it's a district survey, it would be in the opt-out portion, so unless someone opts out. And also, it's not part of, that particular example is not one of the 8 things covered.
Right.
Okay.
And I think that even, so say it was something with the US Department of Education, and it was for that purpose, I think then the district would kind of have to do a little bit of a PR campaign of, this is what, you know, we're doing this, and this is why we're trying to get $1 million grant, and this is why we need this information, to get people to opt in for that particular survey.
Is there a way to carve out for grants?
It's illegal behavior.
Is there a way to carve out, or would you want to carve out for grants?
I don't know if legally, I don't know what the legal answer is.
So, the only grant that you could potentially have an issue is US Department of Education.
Mhm.
If the grant is New York State or anything like that, you'd be in the second part and you're in an opt-out, not
Right.
an opt-in.
But, so Title I funding, Title II funding, Title III, Title IV, federal grants.
It's not really being funded by the USDA.
I know.
Sorry.
No,
I
no,
had to say it.
no.
But yeah, okay.
But it
I'm
does,
just wondering if there's any, if this
But even
handcuffs
there,
us in
we
terms of
still-
grants.
I guess it would depend on what the grant is, you know, grant says. You'd be giving the survey to whoever, I mean, maybe 4 people, who opts in and
Okay.
gives permission.
I mean, my reading of this, and it may be wrong, if there is a grant being offered, not by the DOE, through an independent organization, that, you know, to support substance abuse issues in communities.
That would be a district.
That would be a
That would be a district survey, but if you're, if you're interviewing minors about even the use of substances that are legal for
Adults.
21 plus, right? Then you're covered under this illegal, antisocial, self-incriminating, or demeaning behavior, right? So would that have to be an opt-in because you are addressing a certain category of information?
No, because we're saying in here that if it's so basically this is the federal grant, so since it's not the US Department,
Right,
funded.
but it does say surveys that gather any of the following information are subject to certain parent, guardian notification and consent requirements or student notification and consent if the student is 18 years old.
Right, so, and these are the requirements. So the requirements are if it is US Department of Education funded, then we need to get your consent for each particular survey. If it is district administered, you need to have opted out in order for us to need to get further consent.
Okay.
Option A.
I see, so,
So, are we confusing things by not putting that first?
yes, that's just what I was gonna say.
And why are we bifurcating it, just to understand? In other words, if we're saying opt in for one and opt out for others, what would be the?
Well, the first part, we have only an opt-in option, we don't have a choice. And my understanding was the opt-out is that if the data is beneficial to the district, we want more
You'll get a higher
participation.
response
We
rate.
we hope for a higher response rate.
So with regard to not having an opt-out, I could create a version that you have to opt out to either one of them. I'll confirm it, but I believe, I can.
So do we wanna switch the order here?
It says, according to the law, that the law requires written consent
Consent,
from
so
the
then-
parent.
Yeah.
So it's only an opt-in
Okay.
for that, there is no option for opt-out.
I think we could either switch it or reference it to say that surveys that gather any of the following information are subject to certain parent, guardian notification and consent requirements or student notification and consent if the student is 18 years old. In the paragraphs that follow this.
As provided below.
As provided below, right, so that we reference those paragraphs, because when you read it on its face, it does sound like anything that addresses any of these
Right.
8
Yeah.
Right.
categories of information.
So I think if we, I do think, are subject to certain parent, guardian and consent requirements as provided below, so that they know to kind of like look there.
Okay, then on page 3, we have a highlight. All requests to inspect third-party surveys must be made to the building principal in certain time frame. Blah, blah, blah. So, whatever.
So, I mean, you want to give some time, because then we're making sure, I mean,
My thought?
Yeah.
My thought was take the second option and say within 7 days prior to the date of the survey.
What am I, what's second option?
Oh, after the or within 7 days
You can
prior.
do within 7 days of the notice, or you can do within 7 days prior to the date of the survey. I was thinking,
Sorry, where does it say that?
Like that, when you were referencing it.
top
there's
of
two
page
options.
3, the highlight, gives you 2 options.
oh, it's funny, mine doesn't.
Mine does.
Mine doesn't.
It says insert time frame, comma, such as within X days.
Oh,
after
okay.
the notice was
So you're suggesting
Or-
7?
Or,
Oh, I see. Oh, okay.
so I like the second part,
I think the second part works better,
it's
because,
cleaner.
yes, and if you, whenever you get it, you're gonna give it out, and they have 7 days before, like, what the date is,
Right.
and you don't have to deal with, well, if it's say something, different buildings, you have different notice requirements on different buildings.
I thought it would just lead to consistency.
Yeah.
Okay.
And
Then,
is there a reg or exhibit, is there a form that we have for that, or is it simply an email request?
Just
Will
an email.
suffice, okay.
well, and that was going to take me to page 4, under notification. Second paragraph, or actually the full paragraph under the note. The district will notify parents, guardians, I write how. Says at the beginning of the school year and when enrolling students, but how? Do we specify how? What is our practice? Do we not want to? Is there a letter? Is it used to be in the calendar?
I was just gonna say, do you still give out a paper calendar?
No.
So,
I think now there are electronic letters that go out and they
Yeah.
discuss FERPA, but I don't know about PPRA, I don't.
so we could do it the same way with, it's all kind of the same, so we could do, so districts usually still do FERPA and PPRA all kind of the same time. I could provide you with a notification.
That'd be great.
So district will notify parents. So do we wanna say how, or just district will notify, cause
So-
it might change?
Things could change a different way, like, so I think it's the idea they have to be notified.
Okay,
I would recommend not putting how, because then if you change the how, you have to change the policy.
okay. I don't have anything else.
I have a couple more questions. As long as we're on, I think, page 4 now. The section on invasive physical examinations. I'm wondering if the first 2 paragraphs in that section are required in this policy by law.
The
In the note,
highlighted,
in the note.
So make
that's
the
all gonna be
note part of,
deleted.
make the note.
That's all being deleted, okay. I was trying to understand the use case for this information. It seems very specific, very, very niche. So if it's just required by law that we have language on it in
Yes,
this
and
policy?
but that highlighted is not going to be in the
Okay.
policy.
But it does define invasive physical examination in the
Yes.
second paragraph.
Yes. That's helpful. Okay, and I guess I'm gonna open this can of worms under inspection of instructional material, because we do provide language on opting in and opting out on surveys and the inspection of surveys. Is there anything we need to consider in this section of the policy with respect to the recent Supreme Court decision on parental actions in response to?
So it definitely would not be in this policy.
Okay, good.
Um,
Then we can probably end the
So,
conversation.
so one of the things that we're looking at is kind of where it needs to, because it is very specific, so people are obviously making it sound much broader, that
Yes.
people have the right to, that we don't think there's gonna be much change, because it really has to be tied to religion, and, so it is a very
Narrow
specific.
policy,
So
yes.
that is one of the things that we are looking at to see if there's language that we think needs to be added into a policy, or, I had, one of the things I'd recommend is maybe do one of those pop-up webinars about, that, because that's something that as the year goes on, I think is going to be.
And I expect you're getting a lot of questions from districts about.
Those webinars are helpful, by the way.
Very helpful.
Did you see the one from Thursday?
Is it recorded? Can you
Yes,
send
it was on student discipline, no.
But also inspection of instructional material is part of PPRA. And it doesn't talk about opting out of anything or complaining about anything. It just, PPRA just gives the parent the right to inspect.
It's limited to the inspection,
Right,
not
it's
to any
very limited,
action.
just the
not to any
inspection,
action
it's
that
not
follows.
opting
Correct.
out or anything
Okay.
like that, yeah.
Correct.
Okay.
So I think for the purposes of this policy, we're okay just sticking to the inspection part of it.
Yes.
Okay. Any comments from Dr. Shields, Dr. Posse?
Well, it's a good thing we covered 2 things so you didn't have to be there the whole time.
So I know that there was, and I'm not trying, I said I will
Yeah,
leave, whenever you want me to
I'm
leave.
sorry, can we do this first read?
Is that okay with you?
Yeah,
Okay.
we'll make our revisions. I think the revisions are pretty straightforward.
All right, so 5550 is first read.
Do you wanna go over the student records while I'm here? That's the one we were having the discussions
Yeah.
about the directory information, and if you don't want to, then I could.
Yes, however, we are usually clocked to stop at 11:30. We do have one community member. I don't know if there are any community comments. And we're mindful of Dr. Shields and Dr. Posse's time.
No problem, I was just.
So I can defer to everybody here, but I want to
And
be
we could do
very
it another month if you
respectful.
want to also, it's
That would
fine.
be,
No
If we
problem.
could, if that's all right with you, could we
It's fine. I can
invite
come
you
to-
back again?
I can come back, I will put them in my calendar. And if you, what I'll do is I will put all the dates in my calendar so that, and if you want me, I will be here.
Very kind.
Thank
Thank
you.
You're welcome,
We-
thank you.
That is very helpful.
we can open it up to community comments now? Any community comments? None. So we have 5 minutes, we can end early. Lost
What will I
time.
do with it?
Sorry about that. So actually with our 5 minutes, I just want to say, we did discuss some general goals as a committee and also with Dr. Shields prior to this meeting. So I just want to let the community know, we're going to continue to adopt and revise mandatory policies. I think we're almost there. We do have the NISBA chart. I think maybe there's just 1 or 2 policies that are on the mandatory policy that don't apply to Port Washington, but we're so close to getting that set. Also, we will want council's input to review the policy manual and highlight any egregiously out-of-date policies. So you will see along the way that we're trying to catch up from the late 20th century, no joke. But anything that is egregiously out of date, not only in terms of the year, but content is really much more important. Also, we're asking council to review ministerial policies that can be handed off by the committee. So something that's so purely legally technical, kind of like PPRA, but that we already have the policy on the books, but the law has changed, we just need to be brought up to date. That would be helpful if you see anything glaring.
So one area that there's probably, that kind of fits into that thing, it's important, is special ed policies.
Been there, done 'em.
Okay,
The
good.
whole year.
Perfect,
Yeah.
because that's usually it.
One of your colleagues spent most of the year with us last year.
Rachel Roth was.
Rachel, yeah.
Up to code.
Yes.
But I will say, we spent a lot of time in committee because of the philosophy
Well,
of
right, and
the
that's what
district. But yes, we,
See,
yay. But if there's anything else that comes to mind, let us know. Third was identifying policies requiring board annual review, and I don't mean by the state.
right,
Because
for
we
you,
have
I
that
actually think
list.
I have a list of those.
That would be really wonderful, because we've sometimes inserted, for example, we've
Yeah.
done with the harassment policy, where we're not required by law to review the policy, but we've decided that's something we want to do.
Oh, look, I will get you either way, but I believe that I did that for another district too.
Thank
so.
you. And finally, we want to focus our attention on policies, once we get past some of this really legal kind of stuff, that have the greatest impact on student experience and outcomes. And then if there's anything that aligns with whatever goals we happen to adopt, we're gonna try to focus on that. But just so the public knows, our policy meetings are constantly changing in terms of what we want to accomplish, what we get to accomplish, because sometimes one policy will take an hour, and sometimes it's 5 minutes and we're done and we move right along. Sometimes something will come up out of the blue and we have to put it onto the agenda, so policy is very, very fluid, right? And we're always just trying to be very flexible, so. With that, it's 11:28, and I guess we can end. The next meeting date is October 24th, same location. So with that,
Thank you.
adjourn.
Thank you.
Thank you very
Thank you.
much.
Thank you.
Thank you again,
October
Mara.
24th.
Fourth Friday.
Okay, so I'm just gonna say one thing, I actually cannot come to that one because I'm speaking at the convention, the NISBA convention.
Wonderful.
Oh, very
So
nice.
we'll just put on policies that
Perfect.
That we don't need you
don't
for,
require.
Yes,
yeah.
so.
possibly.
Otherwise I would have been, and it's at the same time, so it's
No,
not
no,
even
no,
like I.
right, it's the NISBA convention.
Doing the do's and don'ts on executive session.
Okay.
We don't usually do very uplifting, exciting topics.